Mr. Oakley?
May it please the court, I'm David Oakley from the law firm of Andrel and Oakley, appearing on behalf of Guillermo Quinones, who is
Very well,
present
Mr. Oakley.
by
Welcome, Mr. Oakley. Please extend the court's heartfelt sympathies to Mr. Andrel, who's a very valued member, a beloved member of our community.
Yeah.
Will do, Judge. Thanks.
State of New Jersey versus Guillermo Quinones. It's a state indictment of 19-09-109. Mr. Quinones pled guilty to count 4. It's a pattern of official misconduct, a third-degree offense, which statutorily has a mandatory minimum period of parole and eligibility of 2 years. The state, in a exhaustively negotiated plea with Mr. Andrel, agreed to deviate from that statutory mandatory minimum to a 1-year period of parole and eligibility. Is that accurate, Ms. McCluskey?
Yes, it is, Your Honor.
Mr. Oakley?
Yes, Judge.
Very well. Before my first question is to you, Mr. Oakley. Does Mr. Quinones stand by his guilty plea?
He does, Judge.
Any additions, corrections, or modifications from the pre-sentence investigative report?
Judge, as I indicated in my sentencing memorandum, we do not agree with the factual recitation of the facts in the pre-sentence report, specifically with respect to our disagreement has to do with the amount of loss, which is not as a matter of conspiracy, but it's just a matter of his own actions, which is attributable to Mr. Quinones.
So you don't dispute that this substantial scheme to defraud the taxpayers of the city of New Brunswick resulted in a loss of over $250,000. You don't dispute that?
I don't, Judge, and I think that the number that was put forward in the PSR was significantly less than that, and it was attributing it to the direct actions, attributing it directly to the actions of Mr. Quinones. And let's see. I'm sorry,
No,
Judge. I had it
I'm
right
not
here.
here, Mr. Oakley. I'm not here to try the case.
I understand, Judge.
Yeah. So this is not atypical where a defendant's view of the underlying facts somewhat differs from the government, but your client, and I took the plea, entered into it and knowingly, voluntarily, and intelligently waived his right to a trial and admitted that he committed the third-degree offense of a pattern of official misconduct. So I note your objection for the record. Ms. McCluskey, do you want to be heard on that?
Judge, the only thing I'll say is Mr. Quinones pled guilty, and as a co-conspirator, he's liable to the full extent of the losses to the city, as are his co-defendants.
And certainly he is for purposes of restitution, but he didn't plead to a conspiracy.
Understood, Your Honor, but for purposes of restitution, the state at the time of the plea indicated that it was the city of New Brunswick who would determine the amount of restitution attributed to Mr. Quinones based on the differences between the ultimate loss and that the restitution paid by all of the other 19 co-defendants in this case.
There was an agreement between the state and the defense in terms of what the restitution paradigm would be, correct?
Yes.
That's my recollection. Mr. Oakley, you don't refute that, do you?
No, Judge. I'm just just going back to the original question Your Honor asked about the PSR, and I wanted just to say that I have a complaint. I disagree with a statement on the top of page 3 of PSR about the amount of the attributable directly to my client's actions, and I stand by my factual recitation, which puts the number around $200 from 2 people. That's all. Nothing more, Judge, nothing less.
Very well. So the defense's position that Mr. Quinones's personal take was $200. The state recitation is that he took approximately $1,000.
Exactly, Judge. That's in the PSR, page 3, and I'm disagreeing with that.
Understood. I note
Everything
your
else is fine,
objection.
Judge.
More relevant to me, however, is that your client stands by his plea as to committing a third-degree offense of a pattern of official misconduct, correct?
Judge, there are two bribes, and that's a pattern, and yes, he stands by it.
Very well. Any objections to the pre-sentence investigative report from the state?
No objections, Your Honor.
I want to compliment the lawyers for submitting what I viewed to be very helpful and very exhaustive pre-sentence memoranda. And a number of letters were submitted on behalf of Mr. Quinones, each of which I read. Letters from the defendant, which requests a probationary sentence, a heartbreaking letter from one of his sisters who suffers a relapse of cancer, another letter from a sister, a letter from his fiance, from his daughter and his son and daughter-in-law, from Mr. Wyman, who we are fortunate to have on this Zoom as well, outstanding, longstanding criminal defense lawyer who I've had the pleasure of having before me on any number of occasions, who attested by way of letter that Mr. Quinones is now a valued employee of his. And it's very clear from the photographs which were submitted by Mr. Quinones' family that he enjoys an extremely close-knit family. This is obviously a very difficult time for the family and for the defendant himself. Before I get going in terms of the aggravating and mitigating factors, I want to assuage the anxiety of Mr. Quinones' son and his daughter-in-law, and that is the majority of that letter recited dire statistics of individuals who are incarcerated and COVID contraction. I am mindful of that. Now, Mr. Quinones is a relatively young man. He's 50 years old. No serious health concerns have been reported to the court. But I want at the outset to make clear that I do not intend to have Mr. Quinones voluntarily surrender until he's vaccinated for COVID. So if his family is understandably extremely concerned, not only about him being incarcerated, there's not a whole lot I can do about that, but there is something I can do on a humanitarian basis to not unnecessarily subject him to a risk. He is not in any regard a risk of flight. He's about as ensconced in his community as anybody that's come before this court. The risk that Mr. Quinones is going to take off, I put at about zero. You disagree with me, Ms. McCluskey?
I agree with Your Honor.
In addition, he doesn't pose a risk at all to the safety of the community. This is a serious offense. It's a serious breach of public trust, to be sure, but it is not a crime of violence, and he has no violence on his jacket. I think he's got a disorderly persons offense that is almost 30 years old. That's the entirety of his criminal history. Correct, Ms. McCluskey?
That's the state's understanding.
Mr. Oakley, am I right?
Yes, Judge, correct.
Okay. Mr. Quinones, are you standing, sir?
No, I'm sitting.
Okay, good. Now I'd like to review the aggravating and mitigating factors. I'm going to pull up on another screen. So the state, in its memorandum to the court, requests aggravating factors 3, 4, and 9. Correct, Ms. McCluskey?
Judge, the state requested aggravating factors 3, 4, 9, 10, and 11.
Oh, yes. Yes. I need to go to the next page. With regard to aggravating factor 3, risk of recidivism, I find no basis in Mr. Quinones's history. There's certainly no indication in the PSI that he poses a risk of reoffending. He's forfeiting his right or he's forfeiting his employment, his public employment. I don't believe he can ever obtain public employment again. And I just don't see any basis whatsoever for the risk of reoffending. If you want to be heard in addition to your memo, I'm pretty clear about this, Ms. McCluskey, and I think I'm immovable on this, but I want to give you an opportunity to be heard.
I have nothing further, Judge.
Very well. I do not find 3. Aggravating factor 4 is a lesser sentence will depreciate the seriousness of the defendant's offense because it involved a breach of the public trust, and the defendant took advantage of a position of trust or confidence to commit the offense. Clearly, that applies. Mr. Oakley, I don't think you object to the spirit of it, correct?
No, Judge, but I do have got a concern about the double counting aspect.
So do I. So do I. And so I agree, Ms. McCluskey, that if one were to have a plain reading of aggravating factor 4, it would seek to apply. But I too am concerned about aggravating factor 4 triggering a double count.
Understood, Your Honor.
Very well. I will not find aggravating factor 4. The next is 9, the need for specific and general deterrence. Do you want to be heard on this? I have a pretty clear understanding, Ms. McCluskey, of the state's argument and frankly, how the facts and circumstances of this case significantly trigger specific and general deterrence. Anything else you would like to add?
Your Honor, nothing in addition to the state's sentencing memorandum, except just to reiterate that this is a breach of the public trust. It's a serious offense, and there is a great need to deter specifically this defendant and others.
Mr. Oakley, anything you want to say in response to that, sir?
Well, you know, Judge, this whole process, starting with the statute, you know, culminating in Your Honor's sentencing discretion, however limited, is all about deterrence and whether or not I'm going to be able to overcome the legislative determination that deterrence is so acute a need. So what can I say? I mean, I won't even, you know, even my adversary, who I, you know, can't trust to be totally objective, you know, hasn't exaggerated the, you know, the deterrence, you know, interest here in this case. The question is really, does my client overcome, you know, this heightened deterrence need?
I've carefully considered the facts and circumstances of this case and Mr. Quinones's role in it. And without question, the defendant significantly abused his public trust here. The fact that his personal remuneration from this extensive fraud was rather de minimis or minimal adds to the tragedy of this and the incomprehensible unfortunate actions of Mr. Quinones, for which he's solely responsible. But the need for specific deterrence is very compelling here. We have an individual who was integral, even if his personal take was minimal, to the fraud, this extensive fraud. And a very clear message has to be sent to Mr. Quinones specifically, and also, frankly, to all would-be public servants. New Jersey has 566 municipalities. We are the most congested state in the union. There are tens of thousands, maybe more, public servant, public officials who are similarly situated to Mr. Quinones, who have access to abuse the public trust for their own financial gain to the detriment of the taxpayer. And the need for general deterrence in this case is frankly indicated by the fact that there's a mandatory minimum sentence. So the legislature has taken this into full account. And I find, therefore, that the need for specific and general deterrence here requires the court to give great weight to aggravating factor 9, and I do so. Now, the state also seeks aggravating factor 10. The offense involved fraudulent or deceptive practices against any department or division of state government. I agree clearly this factor applies, but I also believe that we run the risk that we ran Ms. McCluskey in aggravating factor 4 of double counting. Am I wrong?
Judge, I would just add that this factor is a little bit different than the more specific factor involving the breach of the public trust. Again, the legislatures have devised this framework of aggravating factors with all of that in mind. Here, it's not just a public, any sort of general public corruption crime. This is a public corruption crime that sought to defraud a very specific agency of the government. And for that reason, on the black letter law, it should apply.
Mr. Oakley, do you want to be heard on that, or do you defer to the court?
Judge, no, I have to register my disagreement. I don't know if it really is going to matter at the end of the day, but no, I think that, if Your Honor is inclined to agree with me with respect to aggravating factor 4, kind of for that reason, all the more, factor 10 doesn't apply. I mean, there's just plenty of people out there who are ripping off the government and they're not public employees. And so they don't come under a statute, in a chapter, which is specifically aimed at them and enhances their punishment already. So I think it's a very clear case of double counting. That's all, Judge.
Yeah, I don't agree with you. I think Ms. McCluskey prevails on this. I'm looking at aggravating factor 4, which involves a breach of a public trust, which more squarely is implicated by the offense itself, pattern of official misconduct. Here, aggravating factor 10 is more generalized in my judgment, that it specifically notes a fraud or deceit with regard to a division or department of state government. And I can see how circumstances could exist where 4, such as I found, is not implicated, but 10 is. I will find aggravating factor 10. I give it really in light weight. So I find it applies, but I give it minimal weight. 11, the imposition, aggravating factor 11 is the imposition of a fine, penalty, or order of restitution without imposing a term of imprisonment would be perceived by the defendant or others as merely a part of the cost of doing business or as an acceptable contingent business or operating expense associated with the initial decision to resort to unlawful practices. I cannot see, Mr. Oakley, how there would be leveled an objection to that.
I'll just stay on mute, Judge. Thanks.
Yeah, clearly aggravating factor 11 applies. And frankly, this is the crux of the argument that I expect to hear and did hear from both Mr. Oakley and Ms. McCluskey in your sentencing memorandum. And very clearly, aggravating factor 11 applies, and I give it significant weight. If the court were to deviate from the legislatively compelled mandatory minimum, which the state has already deviated from, a very clear message would be transmitted that there's a minimal cost of doing business for engaging in a breach of the public trust, such that Mr. Quinones admitted to. And so I find aggravating factor 11 And I give that significant weight. So I find aggravating factors 3 and 4, Aaliyah, do not apply. I find 9, both specific and general deterrence, clearly apply in terms of an aggravating factor, and I give it great weight. I find 10, aggravating factor 10 applies. I give it minimal weight, and that is that the offense involved fraudulent or deceptive practices. And I find aggravating factor 11 applies. I give it great weight, and that is that if the court imposed only a financial penalty here, it would send a clear, unmistakable message to other would-be unlawful practices in the public sphere. And therefore, I give it great weight, 11. Now, let's turn, if we would, to mitigating factors.
Judge, just before we go there, just to make it all, this is very organized and everything, and I admire your Honor's approach. I just before we get to mitigating, this is not an argument, Judge, but how would your rejection of factor 3 be consistent with your application of factor 9 with respect to specific deterrence? It seems to me that this factor 9 in play is really the second half of factor 9, which is the general deterrence, that it's really about deterring the rest of the public. If so far as Mr. Quinones is the last person, I think, to really be committing another offense, then, which is consistent with the rejection of my adversary's invocation of 3, I think 9 only applies insofar as it's general.
I don't agree with you. This scheme was extensive. There's nothing that indicates to me that Mr. Quinones necessarily is going to reoffend, which is the case law would support an extensive juvenile record is indicia of reoffending. Drug and alcohol abuse, that he's committed crimes of a similar nature. I know you're familiar with the case law, as am I. None of those trigger aggravating factor 3. However, this was a well thought through scheme to defraud. He was integral to it. There needs to be a severe, as the legislature has designated, there needs to be a severe custodial punishment imposed, which dovetails with specific deterrence. And so that's the court's findings. I understand what your argument is, Mr. Oakley, but frankly, what you're really saying to the court is every time the court finds that aggravating factor 3 doesn't apply, that necessarily vitiates specific deterrence under aggravating factor 9. I've not seen a case to support that. And frankly, I think another judge could conceivably find the extent of this fraud, Mr. Quinones' active involvement in it, might be indicative of the risk of reoffending. I'm not finding that, but I think a reasonable person could have a contrary view consistent with Ms. McCluskey's view. But more to the point, I'm not familiar with a case which indicates if a court does not find aggravating factor 3, he or she must necessarily not find specific deterrence under 9. I don't think they're mutually exclusive. Okay. Now, let's go on to the mitigating factors. The defense, in its memorandum, recites a litany of potential mitigating factors, including 7, 8, 9, 10, and 11. Correct? Am I correct?
Muting. Yes, Judge, that's correct. I don't know, my computer was not responding.
Well, we can do 7 and 10. We can do 7 right away. He has no history of prior delinquency or criminal activity. And the defense does not dispute that mitigating factor 7 applies. Correct, Ms. McCluskey?
No dispute there.
It appears, frankly, that that was taken into consideration by the state in terms of deviating from the general statutory minimum of 2 years parole ineligibility. Is that accurate, Ms. McCluskey?
It was that, Your Honor, coupled with some degree of cooperation.
Understood. Therefore, I certainly will find mitigating factor 7. I give it moderate weight. Certainly, it needs to be recognized, and it is being recognized. I give it moderate weight. 8, unlikely to recur. And the defense's argument, I believe, is he's forfeiting his position of a public trust and cannot reapply, and therefore 8 applies. Correct, Mr. Oakley?
That's correct, Judge.
What says the state in response to that?
Your Honor, the state's argument here is that the only reason that these circumstances can't recur in this exact same way is because as a result of Mr. Quinones's conduct, he is barred from ever holding public office again. It's not that these circumstances are so unique, as I imagine the law perceived, that they cannot recur again, or that Mr. Quinones is taking it upon himself with demonstrated steps to show the court and the state that these are circumstances unlikely to occur. This does not show that had he been given the opportunity, or would he be given the opportunity, he wouldn't take it again. And it also doesn't mean that if working in some sort of private capacity, he couldn't take the opportunity again. The defendant can't get the benefit of, he can't receive he can't forcibly be stripped of his ability to work in the public trust and then use that as a mitigating factor. The state objects to the imposition of that mitigating factor here.
I think you're incorrect on this, Ms. McCluskey. I think if you read the very plain language, which is what the court is required to do, and impute reasonable interpretation of the language, it clearly applies here. What you're asking me to do, most respectfully, is to surmise, is there any conceivable theoretical possibility that Mr. Quinones in another context could engage in a scheme to defraud? Well, the answer to that, of course, is yes. But that's not what 8 requires. 8 requires the court find that it's unlikely to recur. There's nothing in Mr. Quinones's history, aside from this case, that indicates, like I indicated under aggravating factor 3, that he's likely to reoffend. He's going to be paying a rather severe, and perhaps appropriately so, punishment pursuant to the plea agreement. But I see nothing here which indicates that he's, I don't want to use a double negative, not unlikely to commit another offense. I don't see there's nothing you've pointed me to other than a hypothetical. And I'm not quarreling with you. That's all you have. Lawyers can't make things up, or they shouldn't make things up. But I see nothing in Mr. Quinones's background to indicate that mitigating factor 8 does not apply. I see everything which indicates to me that it does. So I will find mitigating factor 8. I also, under the context of this serious case, give it moderate weight. 9, the character and attitude indicate that he's unlikely to commit another offense. I note the state's objection. This is trickier to me than mitigating factor 8. This is not a situation where Mr. Quinones, out of guilt or sense of responsibility, voluntarily revealed the fraud and his participation in it. This is a significant, frankly, criminal enterprise. And so while I certainly see a basis for 8, I don't see an indication regarding his character and his attitude indicating that he's unlikely to commit another offense. I do think the circumstances are such that it's unlikely to recur, but I don't see anything extraordinary regarding the conduct of this defendant, which would give me confidence in finding mitigating factor 9. 10, and so I don't find it. And listen, let's be clear. There's a significant overlap in a lot of these mitigating and aggravating factors. And I'm sure counsel is scratching its head, as it perfectly appropriate. And the court has to make very specific, nuanced findings, which are not always easy to do, particularly with double counting and the like. And I'm endeavoring to do the very best that I can to be fair to the defense and also to the state. Though I can see on the Zoom, there are occasions with Mr. Oakley's eyebrow is raised, which I'm interpreting as, and understandably, and I'm not quarreling with it, he's being entirely respectful, but I think he disagrees with the court's findings. He's entitled to do so, frankly, as is Ms. McCluskey. The next mitigating factor is 10, that he's particularly likely to respond affirmatively to probationary treatment. That's when I indicated to Ms. McCluskey before that was aspirational in terms of risk of reoffending, and I think mitigating factor 8. I think this is also aspirational. There's no data provided to the court other than the self-serving letters for people in support of Mr. Quinones, which indicate to me that he's particularly likely to respond affirmatively to probation. I want to note the following. That finding is circumvented, if you will, from the plea itself, which requires a term of incarceration as per statute. So I do not find 10. 11, the imprisonment of the defendant would entail excessive hardship. Now, there's no question, and Mr. Oakley's submission makes it clear, that incarceration here poses a hardship. There's no question about it. But it is the regrettable, tragic collateral consequence of Mr. Quinones's actions in this case would bring this to bear. He is solely responsible for placing his family in this position. It is a very high burden indeed to show an excessive hardship. Mr. Quinones has a loving, devoted family. One of his sisters who is ailing lives with him, and he's taken, as devoted family members do, a significant role in her caretaking. But there are other adults that live in that household that, in the breach, may fill the void of Mr. Quinones's absence. This is not a situation where unfortunately I've seen time and time again, where you have a sole caretaker of a very sick child, and the child would be placed in foster care, that the family is on the verge of financial collapse, etc. Thankfully, that is not the situation. Mr. Quinones has grown children. They seem to be very devoted to each other. And certainly it's a hardship, to be sure, but I agree with the state. It does not meet the very high burden required. So I do not find mitigating factor 11. I find mitigating factors 7, 8. I think that's the sole mitigating factors that I have found. Is that accurate?
Judge, that your eyebrows, I believe that is accurate.
Very well. Ms. McCluskey, am I accurate?
That's what I have down, Your Honor. Yes, that's accurate.
Very well. I find the aggravating factors of 9, 10, and 11 qualitatively and quantitatively outweigh the mitigating factors of 7 and 8. Now, I turn it over to you, Mr. Oakley, with regard to the sentence. And if you'd like briefly for others to be heard, I, of course, welcome their participation.
Right. Judge, thank you very much. And thank you for your thorough analysis of the factors or the information that we have we put before the court. Judge, as the court, of course, is well aware, we have a heavy burden. I need you, Your Honor, to find by clear and convincing evidence that these extraordinary circumstances exist such that the imposition of the mandatory minimum term here, 1 year, would be a serious injustice. And that serious injustice is one that overrides this heightened legislative determination about deterrence. And Judge, what I want the court to see is that we do have these extraordinary circumstances, that there is this serious injustice, and that those extraordinary circumstances do outweigh the legislative determination concerning the need to deter others from committing these crimes which betray the public trust. Judge, I think by way of background, I need to just say that I am not, just to put it mildly, in agreement with my adversary's recitation of the facts. I did note that Your Honor, in weighing the aggravating and mitigating factors, seems to have adopted, at least for purposes of that 2C:41-1 analysis, my recitation of the facts, but I do have to, register my disagreement with the deputy's recitation. We vehemently disagree with the characterization that Mr. Cannone was somehow the mastermind of this. We vehemently disagree with the amount which could be attributable to Mr. Cannone's. And as for the facts that were proffered by my adversary in her factual background, I can only say, news to me, Judge. And Judge, just when I was making a very important point, my phone went off. Forgive me. And I didn't have it on vibrate. Judge, news to me that Mr. Cannone could have been considered a mastermind in this. No, Judge, I'm familiar. I know that the prosecutor doesn't necessarily share absolutely everything with me. I wasn't there when we negotiated the plea was negotiated between Mr. Andrel and Mr. Robinson, but I did make sure that I knew what the factual basis was. I ordered the plea. Listened to Your Honor. Didn't get the benefit of the video, but I got the benefit of the audio. And I heard the allocution. The allocution had to do with two brides, Ms. Martinez and Mr. Carrion. Right? That was the factual basis. And it just seems to me, Judge, at the time, the factual basis was supplied. The prosecutor could have elicited the full her version, as it were, of the offense. But in any event, Judge, this is not federal court, and we usually don't have these disagreements because we have discovery. And I can assure Your Honor, having reviewed the discovery as I prepared for the sentencing memo, and then and after seeing my adversary's factual background, there's no discovery provided to us, to Mr. Quinones and me, concerning that co-defendants Ortiz and Debonis would have testified in such a way, or that there was a Mr. Mishalov and so forth. All right, so Judge, that's my argument about my adversary's factual background. So Judge, where do I come here? Where I want Your Honor to sort of see and agree with us that we do have these extraordinary circumstances. The analysis, of course, is the 2C:44-1D analysis, more or less. It's a very, I need very compelling circumstances, Judge, and I think that we have them here. I would agree.
Mr. Oakley, you have to concede that the precedential cases on this point present the most extraordinary circumstances. Somebody who's severely cognitively impaired, for example, to subject that person to a period of incarceration, and that's a published appellate division case. I use that only for illustrative purposes. Here we have a middle-aged man who has no such impairment, doesn't suffer from any acute mental or physical disability. There's no dependents that reside with him. There's been no indication that he does not have the psychological fortitude or the physical fortitude to withstand the period of incarceration mandated by the plea. And it's a heartbreaking case, no doubt about it, Mr. Oakley. But frankly, so is every defendant I sentence to a period of incarceration. My stomach hurts every sentencing day. It hurts the moment I wake up, and it persists through the entirety of the day. And Mr. Quinones is a part of that. I don't know if you listened in on any of the other sentences that I had this morning. There were a number of them. Each one of them are difficult and must be uniquely considered. But I don't see anything here which would constitute an extraordinary circumstance resulting in a serious injustice. I just don't see it. And the case law it imposes a extremely high burden. And I don't see it here. I don't even think it's close. Mm-hmm. Having said, from a legal standpoint, mm-hmm. Not from an emotional standpoint, but from a legal standpoint, I don't see this as even a close call.
Right. Well, I don't know, Judge. I think then, the state sees it as closer than you do, because I'm halfway there. I have a plea agreement that knocked off 1 of 2 years. And it just seems to me that the very same factors which the state took into account and lowered the mandatory minimum of 2 years to 1 year, really in all fairness and under the case law, or rather under 2C43-6.5C, ought to lead, Your Honor, the full distance to a probationary sentence. So, Judge, I'm going to rely on my brief. I've made my best argument, and it's all in there, Judge. Thank you. And I direct Your Honor to the appendix, where you clearly are familiar with the letters. And thank you for looking at the photographs that we submitted. Judge, I would just ask, if I could, to let Your Honor hear briefly, of course, from Mr. Weinman and from 2 family members.
Any objection from the state?
I'm sorry, Judge. Objection to hearing from the
yes.
Reporters. No objection.
Good morning to you, Mr. Weinman.
Good morning, Judge.
Nice to see you.
Nice to see you again, Your Honor, especially as a private individual instead of as a litigant.
Well, I hope you enjoy coming as an officer of the court as well.
I do. I only had good experiences in your court, no doubt about it. I handled a couple cases because I'm basically in New Brunswick.
Yes.
There were 2 very good experiences, I must say. I don't know if you remember them, but of course I do.
I remember you, but I don't remember the cases. What were they?
One was this guy, Abed Diab, was charged with burglary, ended up getting it down to a non-custodial probation only. And the other one I had was related to this case, where I did a PTI appeal and I ended up getting PTI. So those are 2 good results.
Well, so what can you tell me? What would you like to tell me regarding Mr. Quinones?
Judge, you're one of the most thorough judges I've ever seen in my 34-year career, and there's no doubt about it. You meticulously went through in such a detailed way. I've got to be so impressed, the aggravating, mitigating. I'm not here to tug on your heartstrings. I know that, my best friend is Joe Paone in Middlesex. I know what it's like to go through. I can't do your job to go through a sentencing. It is so difficult for the JSCs to do this. If you guys have any kind of heart, and I know you do, so I know I just don't want to add to that burden. But about this guy, I've known him about 16 years. He's one of the best people I know. I know him through his younger sister Miriam, who used to work for me after she worked with Hector Rodriguez in New Brunswick, and he's just a wonderful guy, very kind-hearted. I don't think I've ever even seen him raise his voice. I can't believe he even has a DP on his abstract. I thought he was, I never thought he got a traffic ticket in his life. What I really want to say, Judge, is the amount of involvement. I am in New Brunswick, I'm on Livingston Avenue for 34 years, so I see so much. And I can tell you, I don't have a doubt that these guys, the Bonis and Ortiz, would have done all this craziness, whether or not Quinones was there or not. One was a drug addict, had because of his bad hip and his operations. The other one was has a gambling addiction. So they were doing it to make as much money as they can to feed their addictions. It was a scheme. It was an enterprise, criminal enterprise. Quinones tried to be nice to a couple of people, believe it or not, to do something so significant, to use such poor judgment. The motive was to be nice to a couple of people. I think he took $150, maybe $200. He didn't need the money, just wanted to be nice to people. What a stupid judgment to make. But the motivation, to me, is so important, that these guys did it as a criminal enterprise to support their addictions, to go on as best they could, taking as much money from the city of New Brunswick. And that's why Mr. Quinones was charged after everyone. I was surprised he was even charged. Everyone else was basically done with their case before he was even charged. He tried to help out as much as he could. He knows he did wrong. I can't believe he did it, but I just wanted to leave you with that, Judge. He's such a tangential, remote part of this entire horrible thing. They would have done it to support their crazy addictions, whether or not he was there or not, whether or not he was involved. I don't know. Just to let you know the motivations and intentions involved. Thank you, Judge, for listening to me. I appreciate it.
You're very welcome. I often share defense counsel's shock and dismay at the recklessness of individuals to forfeit such a stable, close-knit family and community structure. And this is a perfect example. But I think, and I do appreciate you recognize that the court takes no satisfaction today, none. I frankly would like nothing more than never to have met Mr. Quinones in such a circumstance. Honestly, these are very difficult cases to sentence, but really, what you're really asking me to do when you unpeel the onion is to impose an illegal sentence. And that, you're too clever and too good a lawyer to actually overtly say that. But when you strip it, that's really because there is, I don't believe, an objective judge who could look at these facts and circumstances, the allocution, the plea, the statute, and the incredibly onerous burden of deviating from that, and come to the conclusion that Mr. Quinones presents such an extraordinary circumstance. He doesn't. He presents a heartbreaking circumstance. He presents maybe an inexplicable circumstance. He presents a most regrettable circumstance, but not an extraordinary circumstance under the law. That's go ahead, Mr. Lyman.
I think it's extraordinary, the motives and intentions that these other guys were involved, knowing full well that they were doing something so wrong for such a long period of time that they probably will go to prison for what they're doing.
Didn't they get subjected to the 2-year sentence? I think they did.
I believe they already did. I believe they pled to a second degree, and Mr. Quinones pled to a third degree.
Yeah.
Just to be nice.
The second degree, by the way, is a 5 with a 5 if they go to trial and are convicted. Correct?
They had a waiver, thank God.
Yes.
The AP was able to.
Yeah.
But I felt that the acknowledgement of the degree of participation was reflected by which degree they pled to. And I would never ask Your Honor to impose a legal sentence, of course. I would just think that on a first offense third degree, this might be one of those extraordinary cases because his involvement was so de minimis. It was not to support his life through bribery and fraud and scheming and scamming. It was just to be nice to a couple of people. I'm not going to burden you any further, Judge. Thank you. Thank you.
No burden. Thank you very much.
Sure, Judge.
Mr. Oakley, who else wants to address the court?
Thank you, Judge. Of course, I would like to have his sister Miriam address the court, and then his fiance very briefly. But if Miriam is up for it.
Oh, hold on one second. Mr. Glenn, we are going to be going beyond 12:30. I've got a hearing at 12:30. I think you're going to have to communicate with the jail or the prison, rather, state prison, that we are going over. It would be optimal for me after the series of sentencings to take a psychological break. So I would appreciate it if we can do this at 1:30 or 2. If the jail cannot, then we will go right into it. But that's not my preference, if possible.
Okay, Judge.
Okay? Thank you. I'm sorry about that, Mr. Oakley.
No problem whatsoever, Judge. So, Judge, I was asking for Miriam, his sister,
Sure.
to address the court.
Good morning to you, ma'am. Actually, good afternoon to you, ma'am.
Good afternoon.
I want you to know I did read your letter.
Your Honor, I do apologize for everything that's happened between my brother and the city of New Brunswick Board of Department. I truly believe he'll never, I've been listening to everything, he'll never commit another crime. You know, he's a very just homebody person, family man. Never does anything wrong, doesn't have any bad habits. All he does is take care of me and his family. And I can promise the system, I swear, he will never do another bad thing. He don't have any bad foes. He's just so loyal, he helps everyone. But I told him, we can't help anyone no more. I said, because everything is like a conspiracy, or just for helping someone. Next thing you know, look at what he's lost his life, lost everything. And I'm about to lose him for $200 because I'm listening to what's going on. It's so unfair. Jail's not going to make the difference. He's been in jail. He's been sitting here for the last 2 years in that corner. I have lost weight. I have lost it all. I can't even sleep. My nerves are shy. Everything. My health is just, I need surgery. I don't go to surgery because I'm so worried about what's going to happen to him. And all he's been here 2 years is worse than being in prison. And I think, Your Honor, I understand you, and just trust me. You know, I respect every word you say, the prosecutor, the state, everyone. But please, Judge, if you can consider it, you know, probation would help. But incarceration is just so bad. How you see the statistics in the jail, how many people they let out, okay, the COVID, all this stuff. I said, for this, I'm sure, you know, he learned probation for whatever. He's been here. He's been incarcerated. He doesn't go anywhere. Never did it before anyway. Before this, he doesn't go out. He doesn't drink. He doesn't smoke. He's a family man. We're raised properly. We're raised traditionally. We have family values. This is all we know, him and I. And he takes care of all of us, Your Honor. But once again, I apologize to the state, to the system, to everyone that this has been a burden to. I respect you. I've been there every time in court. I see you, the prosecutor, everyone, Mr. Mark Andrew, which is another thing. I pray for him every day. It's so sad. So much has been going on with this case. But I'm sure, Your Honor, that he's learned a lot. and I learned a lot with him, and I told him no more favors. We can't even help the neighbor because things like this happen. So in our family, that's all we know. We're caregivers. We take care of everyone. And anybody can tell you in the neighborhood in the city, I'm also one. But no more. After this case, I told him, you don't even help the neighbor. We can't, because this, look at what happened. Just because other people, whatever happened, you learned the lesson. Oh, okay, do me a favor. No more favors. You can't. You just can't. These days, you can't. Anything is a crime. It's like
Well,
anything
hold on a
you do,
second,
anyone-
ma'am. Hold on a second. Hold on a second. Everything is not a crime, okay? And you have much to be grateful for. Hold on one second. Let me speak if you don't mind, most respectfully. Nobody is suggesting that you can't lend a helping hand to your community, to your neighbors, to your family members. What you can't do is take money in the form of a bribe when you're a public official. That's what you can't do. And so if the message which is being transmitted to you is that you can no longer be helpful to strangers or otherwise, I think you're getting the wrong message. You seem to come from a beautifully close-knit family. And Mr. Quinones is a central pillar of that family, no question about it. He's not the first person who comes from a beautiful family who should have known better, who got very little in terms of financial reward for participating in a crime, who has to bear consequence. I don't make the laws. I took an oath to apply them fairly. And this is a difficult case, to be sure. And I can see the effect that it has on you. And not just you, your entire household, and way beyond. But I don't legislate. I simply am entrusted and authorized to apply it. And I don't see the very high burden which allows me to exercise discretion here. And I think if I were to subvert the plea, ignore the plea, in the end, that decision would likely be reversed from a higher court, because I don't believe it would be legal to do so. I will say this to you, Mr. Oakley. I invite you to appeal. And there are expedited appeals for sentencing purposes. And if my colleagues in the higher court believe that I abuse my discretion, I will certainly take the instructions from a higher court. But if I'm applying the law as I understand it here, I don't believe I've got the discretion that you wish I had, and that Mr. Weinman pleads that I had, and frankly, the family members beseech the court to exercise. If I'm wrong on this, you come right back to me. That's a fairly expedited proceeding. I believe it's a matter of months. I'm going to allow Mr. Quinones time to voluntarily surrender so this pandemic can cool down and he can be vaccinated. And perhaps if I'm wrong, you'll have an opportunity to truncate what I view to be a legally mandated sentence. Who else wants to address the court, Mr. Oakley?
I can't see on the camera, but I know that one of his fiancée was available and she could speak briefly. She's still there. His fiancée was available. And that's the last one. Briefly, if she's still there.
Sure.
And that's the last one, Judge.
Come on, just say hello, just say. No, come on, just say hello, just say. No,
all right, Judge, doesn't seem like she's in. All right, Judge, doesn't seem like. So we're done. Of course, Mr. Quinones has an judge opportunity now. We're done. And of course, Mr. Quinones has an opportunity now, and will to address Your Honor. And Guillermo, if you will just So
Okay,
now
very
speak to
well.
the
Guillermo,
the court. If you could just now speak to
Yes, Your Honor.
the court.
I could just, yes, Your Honor, say thank you for listening to my family, myself. Say thank you for my attorney Oakley, listening to my family, myself. Appreciate my attorney Oakley and Mr. Reed Wyman. Appreciated. I've done. I know a crime I have to pay. I've done, but I definitely assure you that I will never ever be in this situation I definitely again. Assure you that I will never ever be in this situation again. And I understand that you have to obey by the law or do what the law says, but um, I was just hoping that I would get a probation in this situation, and everyone for helping me and doing the best they can. Thank you, Your Honor.
You're very welcome, Mr. Quinones. Ms. McCluskey, do you want to address the court?
Yes, Judge, briefly. Judge, I just want to reiterate that the Jarbath standard and its progeny from the Supreme Court, Evers and the like, do mean that downgrading from a mandatory minimum is, as Your Honor put it, almost impossible. The standard is what it is. And Mr. Quinones entered into a negotiated plea, the benefit of which afforded him, as Mr. Oakley pointed out, downgrading, having really the statutory mandatory minimum sentence of parole ineligibility. That, Your Honor, is the benefit of early resolution of plea negotiations. Mr. Quinones is afforded a great benefit here as a result of negotiations with which he was an equal party. Frankly, if we were to have gone to trial, Mr. Quinones was facing 3 separate second-degree offenses, and it's the state's position that the proof supported those. We might be dealing with a very different sentencing if that was the way defendant and his counsel elected to go. We're here as a result of a negotiated resolution. As a result of that negotiated resolution, the defendant is going to be sentenced to a sentence far lenient than that which he would have otherwise potentially received. Beyond that, Your Honor, the state rests on its sentencing memo and leaves the remainder of sentencing to Your Honor's discretion. Thank you.
Before I get to sentencing, what is the restitution order? And what is the forfeiture? I can't read it on the plea form.
The forfeiture is $200.
Okay.
The agreed upon restitution in the entered plea agreement leaves the amount to the discretion of the city of New Brunswick. I would have to check with them because what this comes down to for Mr. Quinones' sake is what is outstanding when all of the other defendants paid back essentially the water bills that they didn't pay over the course of time. So he would be responsible for the difference. If every subscriber paid back all the restitution full, it's a possibility that he owes the city nothing more. I would have to check with the city to see what has been paid and what is outstanding.
I'm going to leave restitution open for 30 days. Mr. Oakley, does that satisfy you?
No objection, Judge. That's fine.
Very well. And I'm going to order the forfeiture of $200 in U.S. currency. I believe my remarks throughout this sentencing proceeding should indicate the court's struggle here. We have a middle-aged man with no criminal history who has a very devoted family to whom he is equally devoted. He engaged in a scheme to defraud where his personal take was rather minimal. I share Mr. Weinman's frustration, if you will, with Mr. Quinones's jeopardizing all that he has his reputation, his freedom, for a rather minimal crime. His motivation, frankly, is not terribly relevant here, whether he was out of the goodness of his heart to save his friends or associates a significant amount of money, or whether it was to ingratiate himself with other co-schemers, or the rather minimal amount of money. He knowingly and intentionally committed a pattern of official misconduct, and it requires statutorily the imposition of a period of incarceration. I frankly am grateful that the state deviated from the general minimum of 2 years, because I don't think that would have been an equitable outcome here under the unique circumstances of the offense and the unique circumstances of the offender. I am not a fan of mandatory minimums, and this is an excellent case in point. But I don't make the laws, I simply apply them. If I had discretion here, I might impose a different sentence. I'm not going to surmise, I'm not going to engage in conjecture, but I think every thoughtful judge wishes that mandatory minimums were the exception. And but I defer to the legislature on this. I am required to fairly and equally apply the law as I understand it, and I do not believe the defense has met what I view to be an exceedingly high burden, allowing me to deviate and override the negotiated plea or the statute. As a result, I believe I am compelled to impose the negotiated sentence. I do note that Mr. Anderl and Mr. Oakley are very experienced lawyers. Anybody observing today's sentencing proceeding would know that Mr. Quinones has enjoyed the very best that the legal profession provides. I also do not believe that the state has been unfair, heavy-handed. Frankly, the state is bound by the same statute that the court is. And I think the state has done everything reasonably within its authority to be as humane as possible to Mr. Quinones and his family. I invite the defense to appeal me on an expedited basis as to the sentence. And if the appellate division believes that I incorrectly, under these circumstances, applied the law, they will have no hesitancy in remanding the matter back, which I will handle on an emergent basis, Mr. Oakley. But I will remand, consistent with the plea, Mr. Quinones, to the Department of Corrections for a period of 5 years with a 1-year period of parole ineligibility. I impose the following 1-day jail credit for Mr. Quinones and the following fines as well. Give me one moment, please. I've already ordered the forfeiture of $200 and I'm keeping restitution open, a $50 VCCB, a $75 safe neighborhood fund fee, and a $30 police fund. I'm dismissing counts 1, 2, 3, 5, 6, and 7 of indictment 19-09-109-S. Now, Mr. Oakley, if your client would prefer, I will have him voluntarily surrender immediately. He will then be placed in the county jail for some period of time. And this way, he will have accrue jail credits sooner rather than later, which means he will satisfy the sentence sooner rather than later. If your request in the alternative is to allow him a reasonable time period to voluntarily surrender so that he can get vaccinated, I will certainly abide by that. I don't find that he's a risk of flight or, frankly, a danger to the community. So I really defer to you on this as to how your client wishes to proceed. Some clients, frankly, want to get started immediately. How does your client wish to proceed?
Judge, I may have to come back to you on this, but I'm requesting a surrender date in the future on a date after he's vaccinated.
Okay. Mr. Quinones, I'm not ordering you to get a COVID vaccine, although if I had the discretion, I would order everybody to get one, but I don't. Are you inclined to get a vaccine? Do you want to get one?
Yes, Your Honor.
And did you apply? Did you enroll already on the website?
No.
Why not?
Sent to jail or get probation.
I'm sorry?
I didn't know what was the outcome of the situation. Was I going to get probation or go to jail? That's why I didn't get prepared.
Okay. I strongly urge you immediately to register your name. There's a website. I've done it. Mr. Oakley, did you do it as well?
Judge, no, I have some employment through Princeton University and I'm on a list there. So no, Judge, I have not signed up. But I think if I did sign up, I'd probably be eligible sometime in May or so, you know, given my age but yeah, that's what I understand from other people signing up.
So here's what we're going to do. You're going to assist Mr. Quinones, and maybe Mr. Weinman will as well, on making sure that he gets vaccinated, because here's what I won't do. I will not allow Mr. Quinones to come back before me time and again and simply indicate I haven't been vaccinated. So at some point in time, he's going to have to serve a sentence. So I'm going to be as reasonable and as humane as possible, but I'm not going to allow this to go on and on and on. Understood?
It's understood, Judge. It's very reasonable, and certainly will. My client and I will certainly abide by those reasonable terms.
So here's what I'm going to do. I'm going to give him a voluntary surrender date in May. I strongly urge you, Mr. Quinones, immediately to do everything you can to get vaccinated. Because when you come before me in May, I'm not going to entertain the notion that you weren't vaccinated. Understood?
Understood, Your Honor.
Okay. Aaliyah, can you give Mr. Quinones a Friday? I don't need to be present if we are still in the middle of this. I will be conducting most of my proceedings via Zoom, as I have been. So he will voluntarily surrender to my courtroom, and a sheriff's officer will escort him. Can you give me a Friday in mid-May?
May 14th, May 21st.
I'm going to give you May 21st, 9 o'clock in the morning. You were to appear in my courtroom in Elizabeth to voluntarily surrender. You will first be taken into custody to the Union County Jail. From there, you will go to a processing center for state prison. And then you will be transported to the designated facility, which in all likelihood will be a minimum security facility. But I don't have the authority on designating you. Did I miss anything, Ms. McCluskey?
No, Your Honor.
Do you have any objection to the manner in which the court conducted the sentencing,
I do not.
or allowing Mr. Quinones to voluntarily surrender?
No, Judge, no objection.
Mr. Oakley, same questions for you, sir.
No, Judge, no objection, except we would have preferred probation.
Yeah. Well, I would have preferred the discretion. Anything else?
No, Judge. Thank you for all your time.
You're very welcome. Mr. Quinones, you have the right to appeal. I will tell you that I imposed the very sentence which you negotiated, but you have a right nonetheless to appeal. You've got 45 days to file a notice of appeal. You're entitled to a 30-day extension of time, subject to the approval of the appellate division. Can't afford a lawyer for purposes of appeal. The public defender's office will represent you for purposes of appeal. And you've got 5 years from today's date for a petition for post-conviction relief. Did you understand everything, sir?
Yes.
Very well. Anything from the defense?
Judge, I have nothing else.
From the state?
Nothing further, Judge. Thank you.
You're very welcome. I thank the lawyers for your exceptional courtesy to the court, your professionalism, and your excellent lawyering. And I look forward to having each of you, including Mr. Weinman, before the court sooner rather than later. Mr. Quinones, I wish you the very best. I wish your sister who's ailing the very best. And we'll adjourn. I will say this for purposes of the court staff. We will resume the hearing at 2:30 this afternoon. Okay?
Okay.
I thank you all. Matters adjourned. Thank you.
Thank you, Judge.